By this stage, we have discussed how the threshold question involving other act evidence under Rule 404b concerns whether the evidence is being introduced to prove character propensity or some other purpose. If a party manages to persuade a judge that the evidence is being introduced for a valid purpose, namely any purpose other than the banned one, does that mean the evidence automatically comes in? No. As discussed in Modules 13 and 14, the evidence must still survive Rule 403. But if the evidence does survive Rule 403, now does it come in? Well, not necessarily. The party offering this other act evidence must offer some additional evidence that the other act occurred and that the person committed it. Does the party have to prove beyond a reasonable doubt or by clear and convincing evidence that the other act occurred and the person committed it? No, that would be too time-consuming and lead to lots of mini-trials about other acts. Instead, the burden of proof for other act evidence is quite minimal. The party offering the other act evidence must only introduce sufficient evidence that the jury could reasonably find the act occurred by a preponderance of the evidence. In other words, there must be enough evidence so that a jury could reasonably find that it is more likely than not that the act occurred and the person did it. I like to call this a diluted preponderance of the evidence standard. The proponent does not have to prove that it's more likely than not that the act occurred and the person did it. No, just that a jury could reasonably find it's more likely than not that the act occurred and the person did it. This test is sometimes called the Huddleston Test, after the U.S. Supreme Court case that clarified that this would be the burden of proof.